Some of you I know are regular attenders at our workshops, so just a word or two for the benefit of any newcomers today about the McDougall Trust. We're an independent charitable trust which exists to promote public understanding of electoral democracy, and our name comes from Sir Robert McDougall, who was a member of the McDougall flour milling dynasty. He died in 1938, but in his will, Sir Robert bequeathed some funds with which to endow a charity whose central purpose is to advance knowledge of and to encourage the study of and research into methods of election. And in order to fulfil that mandate, the McDougall Trust's work currently embraces four main strands. Firstly, we own the Lakeman Library for Electoral Studies, which is a unique collection of books and journals and archive material on electoral theory and practice. If all goes well, it'll shortly be relocated from its current rather inaccessible site in Vauxhall to the Bishopsgate Institute, which is near Liverpool Street Station, where hopefully its contents will be better maintained and more easily accessible to the public. Secondly, we sponsor Representation, which is subtitled The Journal of Representative Democracy, which is published both in print and online. Thirdly, from time to time, we have funded research projects in the field of electoral studies. And fourthly, as today evidences, we hold workshops on what we hope are topical electoral issues. And indeed, it would be difficult to find a more topical issue at this moment than the scope for tension between direct democracy as exemplified by referendums and representative democracy as embodied in elected legislatures, assemblies or councils, because as we meet, the government of the day is seeking to have a judgment of the Divisional Court overturned, which relates directly to the role, if any, of Parliament in overseeing the government's implementation of the outcome of a referendum on a hugely significant constitutional issue. So, to explore the question of whether there is, or the nature of any tension between parliamentary democracy and referendums, circumstances in which it may be appropriate to hold referendums, and how they and the associated campaigns should properly be conducted, we're privileged to have with us Nat le Roux. Nat is now the Strategy Director of the Constitution Society, which he co-founded in 2009, and which describes itself as an independent, non-party educational foundation which works to promote informed debate about constitutional reform, and indeed is the author of a widely distributed web article on the EU referendum and some paradoxes of democratic legitimacy. Nat is going to talk to us for half an hour or 40 minutes, and after which hopefully there will be plenty of time for discussion, questions and debate. So Nat, welcome to the McDougall Trust. Over to you.
Well, thank you very much, John, and thanks to the McDougall Trust for asking me to do this talk today. So, the governing norm of the Constitution is the principle of parliamentary sovereignty, which means that Parliament is the supreme legislative authority in the UK and can enact or repeal any law. And unusually, the same legislative process in the UK applies to nearly all laws because we have no separate category.
Problem with the volume?
Is it not working?
One or two people at the back were having difficulty hearing. Can we try again?
How's that? Better? And because we have no separate category of constitutional law which is entrenched with any special amendment procedures. So that all sounds very simple, but where do referendums fit into that model? If Parliament is sovereign, referendums, unless they're treated as purely consultative exercises, would appear to be at best an unnecessary confusion. Yet referendums are becoming more frequent, and on the whole, the legitimacy of those referendums is generally accepted both by politicians and the public. So parliamentary sovereignty notwithstanding, there seems to be an emerging constitutional norm that some legislative changes require direct popular endorsement. But at the same time, there are no coherent constitutional rules which tell us when a referendum is required, or indeed when it might be inappropriate, in contrast to many other democracies where the circumstances in which a referendum should be held are more clearly defined, quite often in their written constitutions. So a British government can, in principle, call or not call a referendum on any subject at any time. To take a recent example, in 2011, the coalition government held a referendum on reform of the voting system, as you may remember, fulfilling a political bargain between the coalition partners. But it could equally well have changed the voting system by ordinary legislation without a referendum. And unsurprisingly, perhaps, because of this flexibility, the history of referendums, relatively short history of referendums in the UK, is characterised by political opportunism. And they have often been used or promised to resolve intractable internal disputes within political parties. For example, Labour's promise of a referendum on the voting system under John Smith in the 1990s. Here, the shadow cabinet was split over the question of PR, and a promise of a future referendum, which Tony Blair incidentally never fulfilled, was a convenient way out of that impasse. An Act of Parliament is required to call or to hold a referendum, but governments have in practice never found it difficult to secure a majority for a referendum, and many of these bills, including the one authorising the EU referendum, have enjoyed cross-party support, and perhaps for the obvious reason that people in Parliament see little political advantage in opposing such a call, at least to date. The fact that each referendum requires its own separate legislation also allows the government to vary the franchise and the campaign rules opportunistically. There are some technical rules in the Political Parties Elections and Referendums Act 2000, but there are no consistent fundamental principles for the conduct of referendums in Britain, again in contrast to the position in other countries. And the timing of referendums has been similarly opportunistic. There was no referendum in advance of the UK joining the European Economic Community in 1973, and the referendum that Harold Wilson held in 1975 was about continued membership following a renegotiation of the UK's position. And that was the first, as I just about remember, and it was the first time I ever voted, I think, the first UK-wide referendum. Now, unlike the Danes, British voters were not offered a referendum on the Maastricht Treaty in 1992, although most people would say it fundamentally changed the terms of our EU membership. And David Cameron's promise of a second European referendum in early 2013 was not in response to any significant change in the terms of British membership, nor indeed was there much evidence of widespread popular demand for it, despite many years of vociferous lobbying by those politicians who wanted us to leave the EU. So Cameron's pledge was intended to placate the right of the Conservative Party and win back UKIP votes ahead of the 2015 general election. It's interesting that the three major referendums held while David Cameron was Prime Minister shared a common and rather curious feature. And in all three cases, that's AEV, Scottish independence, and EU membership, Cameron initiated or conceded a referendum as a device with specific political objectives, and then campaigned actively against the referendum proposition and in favour of the status quo. So rather like the words of the hymn Jerusalem, Mr. Cameron's referendums posed a series of questions which invited the answer no. By contrast, referendums in other democracies and previous referendums in the UK, indeed, have more typically sought popular consent for a change which the government supported. Now, this is actually quite an important point, I think, to which I will return later. So the principle of what we may term the opportunistic referendum seems clearly established, and there's no reason to believe that a government of any complexion will in future voluntarily surrender this rather useful political device. That perhaps requires one qualification. Once a referendum has been held on some issue, a precedent is created which may make subsequent legislation on the same issue politically very difficult without a second referendum. So you might think that if we continue to hold fairly frequent referendums, the latitude of future governments may over time be somewhat reduced. But even that's far from certain. Voters who rejected directly elected mayors in referendums in some parts of England are in fact now having these mayors imposed upon them, albeit in a slightly different form. So in a parliamentary democracy, some types of referendum have the potential to create an intractable constitutional difficulty, and that just stems from the obvious point that if a majority of elected representatives hold one view on a matter, and a referendum shows that a majority of the public hold the opposite view, which manifestation of democratic legitimacy should trump the other? Well, as we said earlier, in Britain, parliamentary sovereignty is traditionally regarded as the governing norm of the Constitution. So it would seem that in principle, a parliamentary majority can always overturn a referendum result. The political reality, as we're now seeing, may be different. Those who voted with the majority will understandably assume that while a referendum that may have been merely advisory in law, Parliament should nevertheless defer to the will of the people. And it may be rather difficult for MPs to stand up to that pressure, implied pressure. This is certainly the view of the present government. At the Conservative Party conference last month, Theresa May made her position on the matter very clear. And quoting, "Those people who argue that Article 50 can only be triggered after agreement in both houses of Parliament are not standing up for democracy, they are trying to subvert it." And she went on to elaborate a, I think, novel constitutional proposition, which my colleague Andrew Blick has, in a recent paper, has christened the May Doctrine. And that is that, according to the Prime Minister, so strong is the mandate delivered by the referendum that Parliament, the devolved legislatures, and indeed the courts cannot question it and have no legitimate role in initiating its implementation, that which is a matter entirely for the executive, who are also solely responsible for interpreting voters' views on the priority which should be given to various objectives in the Brexit negotiations. Well, the May Doctrine seems to me to be a very questionable proposition in two respects. First, it rests on an acceptance that the people have delivered their verdict with, in the Prime Minister's words, emphatic clarity. Well, it does not seem particularly emphatic to me. The majority in favour of Brexit was narrow, 51.9%. That's in contrast to the 67% who voted to remain in the European community in 1975. Now, putting it another way, on a relatively high turnout, 37% of the electorate actively supported leaving the European Union. Now, pro-Remain commentators have highlighted other reasons for viewing the referendum result with some scepticism. The mendacious nature of the campaign, the fact that a significant element in the Leave vote was a generalised protest, that many Leave voters did not properly understand the consequences, and so on. Well, you may agree or disagree with these assertions, but we need to exercise some caution with this line of argument. No doubt many voters were badly informed, but that's also true in general elections. And we really cannot know why people voted as they did. And so we should not overstate our scepticism about the referendum result, in my view. And my view is that the referendum result is a mandate, but it's a weak mandate for an irreversible step. And I'll return to this question of irreversibility later on, and certainly does not justify the sort of hyperbole we heard at the Conservative conference. Second, the May Doctrine implies, this is my second reason for doubting its validity, the May Doctrine implies that a referendum result gives the government a constitutional trump card which allows it to override or bypass Parliament. And that, I think, is a very novel and dangerous doctrine. It was not widely reported, but when Theresa May dropped her support for withdrawal from the European Convention on Human Rights at the time of her accession as Prime Minister, she explained her change of heart on the grounds that she did not think there was a parliamentary majority for withdrawal from the Convention. Now, the political reasons for that change of stance, it was the price of support from one particular element in the parliamentary party, but her explanation is nonetheless interesting, because the government's clear view is that Article 50 of the Lisbon Treaty can be invoked using the prerogative power. So why then can the prerogative power not be deployed to withdraw from the Convention, which is just another international treaty after all, without parliamentary endorsement? Well, there's only one logical explanation for that apparent inconsistency, and that is that we seem to have a new constitutional principle, at least in the view of the Prime Minister and some other people, that a referendum can authorise the government to exercise the prerogative power in circumstances where it might otherwise be unreasonable to do so. Well, last week, the Divisional Court, which, as you will no doubt have noticed, rejected the government's view on the triggering of Article 50. And the core of the judge's reasoning was that when Parliament enacted the European Communities Act 1972 and subsequent legislation, and I'm quoting from the judgment here, paragraph 94, Parliament intended EU rights to have effect in domestic law, and that this effect should not be capable of being undone or overridden by action taken by the Crown in exercise of its prerogative power. Well, that seems to me a very compelling and correct argument, and entirely consistent with the established constitutional limitations on the exercise of the prerogative, which date from the 17th century. The pro-Brexit newspapers, as again you might have noticed, took a rather different view of the matter. Well, the government is appealing to the Supreme Court, but at least according to some sources, does not expect to win after the very unequivocal judgment in the Divisional Court last week. And perhaps in anticipation of this, I think there are some signs that the Prime Minister's argument is shifting a little. In her Sunday Telegraph article at the weekend, Mrs May tells us that, quoting, Parliament voted to put the decision about our membership of the EU in the hands of the British people. The people made their choice and did so decisively. Well, the clear implication of that, it seems to me, is that the parliamentary vote to hold the referendum was also, in Mrs May's view, a vote to implement its result. Now, that's plainly wrong in law, but I suggest it's also a highly misleading representation of the decision MPs thought they were taking in June last year. And let me quote again, and this is from the House of Commons Library briefing paper, which was circulated to all MPs ahead of the second reading debate, quoting, this bill requires a referendum to be held on the question of the UK's continued membership of the European Union before the end of 2017. It does not contain any requirement for the UK government to implement the result of the referendum, nor set a timeframe by which a vote to leave the EU should be implemented. Instead, this is a type of referendum known as pre-legislative or consultative, which enables the electorate to voice an opinion. Now, if MPs had been told at the time that a future government would interpret a leave vote as a binding instruction to invoke Article 50 and to do so without a vote in Parliament, I suggest that the debate on the referendum bill might have been at least a rather less anodyne affair than it was. Well, while we wait for the Supreme Court's ruling and putting aside the specific issue of the scope of the prerogative power, I believe we can draw at least one obvious conclusion from recent events, and that is that there is in fact no consensus amongst either politicians or the public on the proper relationship between Parliament and the popular will as expressed in a referendum result. People's opinions on the issue are mainly a reflection of their views on the merits of Brexit simply, and views which are being expressed, I'm afraid, in increasingly intemperate language. And I think it's unsurprising that there is no consensus on this question because it contains an inherent paradox. There is an unavoidable potential for conflict if a political system has two parallel and independent sources of legitimate democratic authority and this is the key point, no constitutional rules which determine their relationship. It's an issue that's interested political theorists for decades. Within Britain, it has never previously been confronted in practice. Now that seems a bit curious. Why has it not come up before, since we've held quite a number of referendums over the years? And I suggest that there are two reasons. The first is that the problem only applies to advisory or so-called pre-legislative referendums, where the consequences of a vote for change are not laid down precisely in advance. The AV referendum of 2011, for example, was a post-legislative referendum which sought endorsement for a new voting system for which Parliament had already legislated in the Parliamentary Voting and Constituencies Act. So if the referendum result had been in favour of AV, the new voting system would have been introduced without further recourse to Parliament, and there was no potential conflict of legitimacies because MPs in this case had determined in advance the exact legal consequences of both possible referendum results. The second reason that we've avoided this conflict of legitimacies in the past is that until 2016, all major referendums have either upheld the status quo or produced the result sought by the UK government of the day, or both. I'm just going back over the history, including the EU referendum this year, 11 referendums have been held to date, either in the UK as a whole or in one of the constituent regions of Scotland, Wales and Northern Ireland. All have been on constitutional issues, and the great majority have been about transfers of sovereignty. And however the individual question was phrased, each effectively offered a binary choice between the status quo and some alternative arrangement defined with varying degrees of precision. The only exception to that was the 1997 devolution referendum in Scotland, where there was an additional question, second question about tax-raising powers. Now, 3 of these have been UK-wide referendums. The previous 2 upheld the status quo. The 1975 referendum on the European Community, we said, was not a vote to join, it was a vote whether we should stay in, and people said yes. And the result of the 2011 AV referendum was, for no change. So there have been 8 referendums on devolution sovereignty in Scotland, Wales and Northern Ireland. The first 3 of these were in the 1970s. In 1973, Northern Ireland voted to remain part of the UK and not to join the Republic of Ireland. In 1979, Wales voted against devolution, and Scotland voted the same year by a bare majority in favour of devolution. However, there was a threshold requirement in that referendum, an interesting matter which we'll come back to in a minute, and so the proposition did not pass. The subsequent 4 referendums were all for change. Northern Ireland voted in favour of the Good Friday Agreement in 1998, Scotland voted in favour of a Scottish Parliament in 1997, and Wales voted in favour of devolved powers in 1997 and again in 2011. And the 8th and most recent of these referendums was the 2014 Scottish independence referendum, which again upheld the status quo. So, accepting the 1979 Scottish referendum, there have been 4 referendums in total which endorsed change. 3 of these were held in the early years of the 1997 Labour government, which had a substantial parliamentary majority. In each case, although the referendums were pre-legislative, in other words, legally non-binding, the government was a strong supporter of the proposed changes. And so that leaves us with the 2011 referendum on the extension of powers of the Welsh Assembly as arguably the only previous example where a referendum result has gone against the status quo without strong support for change from the UK government of the day. And it's a rather unconvincing example because the proposed changes were of a rather technical nature, arguably not meriting a referendum at all. And there was substantial support for change in the Welsh Assembly and an acceptance at Westminster. It was really a matter for Wales. So I think that the main point stands that the 2016 EU referendum is the only one of the 11 major referendums to date where the electorate voted in an advisory referendum both against the status quo and contrary to the recommendation of the government of the day. And that's why, in my view, the potential conflict between Parliament and the views of the electorate, as expressed in the referendum, has been brought into sharp focus for the first time. So that leads on to a broader question. What is or ought to be the proper role of referendums in the British political system? Are they, as many Bremainers now seem to think, just a thoroughly bad idea, or are there some types of legislative decision which do properly require an additional or indeed alternative direct popular mandate? Well, leaving aside all the recent excitement, looking at the question from first principles, a referendum seems to me to be quite a good method for testing changes in social attitudes on matters such as, for example, same-sex marriage. These are questions where everyone's opinion is of equal value, where many voters have relevant personal experience perhaps, and where MPs may be out of touch with public opinion. And interestingly, in contrast indeed to many other countries, there have in fact been no referendums in the UK on issues of this type, with the exception of the local referendums on Sunday opening in Wales a long time ago. Well, why is this? And the obvious reason is precisely that. On many of these issues, the views of MPs have tended to be out of step with those of the public. So throughout the second half of the 20th century, MPs tended to have more progressive, if that's the right word, views in the electorate on matters such as the death penalty. That may have gone into reverse recently. To take one recent example, polls suggest that 80% of the public are in favour of a more permissive approach to assisted dying. But in 2015, a substantial majority of MPs took the opposite view in a free vote. And needless to say, there's no likelihood of a referendum on any of these issues, precisely because they would present MPs with an unpalatable choice between ignoring the popular will and voting against their own conscience. So the questions that voters have been asked in referendums are nearly all about sovereignty or the devolution of powers, and the AV referendum is the only significant exception to that. Sovereignty referendums, which are nearly always, that's unavoidably advisory or pre-legislative, present two particular difficulties. The first is the issue of asymmetric irreversibility. In the sovereignty referendums, there's an important difference between the consequence of a vote for the status quo and a vote for independence or in the recent case, withdrawal from an international organisation. A leave vote, if implemented, is effectively irreversible, and a remain vote leaves open the possibility of future referendums on the same issue. And that's quite unlike a general election, where whatever the result, voters have an opportunity to change their minds 5 years later. Now, because of that, the asymmetric nature of the consequences of the possible outcomes, many theorists believe that sovereignty referendums should require some form of threshold or supermajority to overturn the status quo. As I said earlier, we did adopt this idea on one previous occasion. The legislation for the 1979 referendum on Scottish devolution set a threshold for implementation of 40% of the registered electorate as the deliberately high hurdle which was not reached. So, to ask a perhaps naive question, why did we not have a threshold or supermajority provision in the EU referendum? After the event, you may recall, 4 million people signed a petition in support of that idea, but it did not really get much of an airing at the time of the decision to hold the referendum. Well, I think it's fairly clear why David Cameron did not entertain the idea. UKIP and the anti-EU Conservatives would have cried foul, which would have defeated the whole object of the exercise. And the Prime Minister was, in any case, very confident, along with most other people, that Remain would win with over 50%. It's perhaps more surprising that no MP raised the point either in the debate on the second reading of the referendum bill in June last year, which was largely focused on whether 16 and 17-year-olds should have a vote, although it's noted in passing that Lord Norton, to his credit, did raise it in the Lords debate. The second peculiarity of these advisory sovereignty referendums is the open-ended nature of a vote for change. There's another asymmetry here. In the 2016 EU referendum, the nature of the status quo, remaining a member of the European Union, was precisely knowable, even if it was quite complex. It consisted of the existing set of relationships between Britain and the EU, together with the limited changes that David Cameron had managed to negotiate. And the nature of the proposed change leaving the European Union was not known or knowable by anyone on polling day, however profound their understanding of the issues. There's another point about voter ignorance. No one could have known. That is because, as is becoming ever more plain, there were many alternative possible relationships between Britain and the EU with very, very different economic and social effects. And it's worth noting that the position at the time of the 1975 referendum was quite different to that. Britain had only joined the European community, which was in any case a far less complex animal than the EU later became 2 years earlier. So most voters would have had a pretty clear idea of what life was like outside. Now, uncertainty about the nature of change applies in varying degrees to sovereignty referendums. I believe that most Scots in 2014, for example, understood quite well what becoming an independent country meant, despite some competing narratives about some matters, particularly the future Scottish currency. The meaning of leaving the European Union was far less clear because EU membership is multi-stranded and voters were being asked to consider a complex set of relationships as if it were a single thing. And the government, of course, which called the referendum, didn't know what it meant either. Indeed, it explicitly declined to give the matter any consideration because it was so confident that the proposition would be rejected. So we're now in a rather curious position. The people who, according to David Davis, when he was being interviewed last week, are sovereign, at least in this matter, another novel constitutional doctrine, have instructed those in authority to leave the EU And that instruction has been generally accepted as binding by politicians on both sides, although significantly not by the SNP. However, the referendum result tells us very little about what alternative arrangements the public would like to see. The government and many others believe that concerns about immigration played a major part in the result, and that taking back control of our borders should thus be at the centre of any new agreement with Europe. Well, maybe, but even this seems to me tendentious. Many voters may have believed that immigration could be dramatically reduced without material damage to their own standard of living. And there's a YouGov poll in August that seems to show that 60% of people would not restrict European immigration if it cost them personally a single pound of income. So how do we interpret the result? And indeed, how do we interpret to whom the instruction has been given? Has it been given to the executive or to Parliament or to some combination of the two? Well, this question was barely considered before the referendum. Now it's, of course, at the centre of the debate. So what general conclusions should we draw from all this about the role of sovereignty referendums? I'll give you my own view about the Scottish and EU referendums, but it's necessarily subjective. And I'm sure that many of you will not agree with me. First, I think that Scottish independence does properly require endorsement in a referendum. It's a decision beyond the competence of either Parliament. However, it does not follow that David Cameron was under any constitutional obligation to facilitate a referendum in 2014 just because the SNP government in Edinburgh wanted one. And if a referendum was to be held, and perhaps it should have been, it should, in my view, have had a threshold requirement. But because it did not, I feel that any second independence referendum must also be on the basis of a simple majority. Second, I think it's clear that the UK government was not constitutionally required to hold a referendum to confirm our membership of the European Community in 1975. Earlier governments have made treaty commitments involving a comparable loss of sovereignty without a referendum. For example, the agreements which allowed US forces to be permanently based in Britain after the Second World War. The 1975 referendum was held mainly to resolve differences within the Labour government, which is a familiar ring to it. Nonetheless, as a consequence of that referendum, it became politically impossible afterwards for any subsequent government to leave the EU without another referendum. But it doesn't follow from that a government which did not wish to leave the EU was in any way obliged to offer us the recent referendum. David Cameron's timing was entirely opportunistic. He was a risk taker by temperament, and until last June, a rather successful one. To a betting man, Mr. Cameron looked rather like a punter whose luck finally ran out in the sixth race of a seven-race accumulator. More seriously for the rest of us, he's also responsible, I think, for a major act of constitutional recklessness, because the conflicts of legitimacy which would manifest themselves in the event of a vote to leave were, in retrospect, entirely predictable. So let me end with a few general thoughts. First, a question. Could we have held a referendum on EU membership without risking a constitutional train crash? Well, under some counterfactual circumstances, perhaps. To take the obvious case, if a government had been elected on a mandate to negotiate withdrawal from the EU, the electorate could have been offered the choice in a subsequent referendum between the status quo and some fairly well-defined set of alternative arrangements. And that might have worked out all right, despite the obvious difficulties of timing and choreography. However, in the actual circumstances of the 2016 referendum, I find it very difficult to see how the messy constitutional consequences of this unexpected result could have been avoided. Second, as I think I've demonstrated, not all referendums create potential conflicts of democratic legitimacy. Post-legislative referendums are fairly innocuous, and it's advisory referendums which are constitutionally dangerous, and even those are unlikely to cause fundamental difficulties if the government supports the proposed change and can get it through Parliament. In practice, serious problems arise only in these very specific circumstances where the government holds an advisory referendum in which it supports the status quo and loses. So it would seem to me reasonable to conclude that, at least in the UK context, a government should not call an advisory referendum unless it supports the change which is being proposed. Third, it seems to me entirely sensible that any referendum on an irreversible transfer of sovereignty should have a threshold or supermajority provision. However, as things now stand, that is rather unhelpful advice. A second referendum on Scottish independence is quite likely, I think, and a second EU referendum is at least a possibility. And if either of these were held, it would be politically impossible to apply any rule other than simple majority because of the precedent set by the previous one. Finally, and underlying all of this, is the fundamental problem of an absence of constitutional norms around referendums, when they should be called, how they should be conducted. And this vacuum allows governments to call referendums for reasons of short-term tactical advantage without adequately considering the constitutional consequences. And they've done that with increasing frequency, and that tendency is only one example of what I believe to be a more general problem, which is now becoming acute. And that is that the British Constitution is now looking, at least to me, dangerously unstable because of the series of uncoordinated changes which have been made largely on the hoof by governments since 1997. This could not happen in most other democracies because they have written constitutions which lay down special procedures for constitutional change. So let me leave the last word to my old tutor, Sir John Baker. A written constitution may not be the best solution for this country, and it may not be practically attainable. But if we are to carry on without one, it would be good if some means could be found of protecting the wisdom of successive generations against the fickle politics of the moment. Thank you very much.
Thank you, Nat. That's extremely cogent and comprehensive and thought-provoking survey of extremely complex and technical issues, and I'm hugely indebted, I'm sure we are, to all of you for putting your thoughts together and sharing them with us this afternoon. Now, we've got quite a bit of time at our disposal. I'm sure there will be questions and comments and suggestions. Just before we kick off, though, into that session, let me just give you a heads up. The next McDougall workshop will be on the 9th of December. That's a Friday. Details will be circulated as usual, but if you'd like to put it into your diaries now, it will take the form of a debate between advocates on either side of the argument about the pros and cons of moving to a system of electronic voting as opposed to conventional ballot papers. All part of, as it were, the wider move towards digital democracy. Nat mentioned in passing that one of the uses to which referenda have been put from time to time in various places is as a means of testing changes in social attitudes. And I am indebted to yesterday's Guardian for the intelligence that one of the down-ballot propositions in which voters in California were invited to pronounce yesterday was the merits or demerits of requiring porn stars to wear condoms at work. Imagination can only boggle at what the, as it were, information material that was circulated to electors to educate them about the issue, what form that can have taken. Right, if you would like to raise a point or put a question, please indicate. And if you could identify yourself and your affiliation, that would be a great help. Who'd like to be first? Gentleman here.
Robert Sprigg, not affiliated
Okay.
with the organisation. Focusing on the EU referendum specifically, when the bill went through, why do you think that the parliamentarians didn't put in any restrictions or terminology you like to use? Were they gullible or negligent?
Well, difficult to know. I mean, I speed read the Hansard of the debate preparation for this, and there really wasn't very much of a debate at all. A number of people made the point that 16 and 17-year-olds should be given the vote, as they had been in the Scottish referendum, and that was inconsistent. But other than that, everybody seemed to think that the referendum was basically quite a good idea, although very likely based on the assumption that the vote would be to remain. The sort of awkward issue would be sort of got out of the way by holding it. That's how I'd interpret it.
At the back, over here.
There was a debate during the committee stage
Could you speak up a little bit? Sorry.
Right. At the committee stage of the bill, the SNP moved an amendment which they tried to get a majority in each of the 4 countries in the UK, as well as the overall majority. I wonder whether that's what.
Well, that's very interesting. I did not know that.
I mean, it was thrown out. That was something that the government.
But it would certainly be consistent with the position the SNP have taken subsequently.
Had it been passed, it would have thrown up a whole interesting extra set of issues. Colin.
Just one point of information.
Sorry, you are, for the sake of...
I'm Conor Rosenstiel, former chair of the Electoral Reform Society. The information on the court case, the court was assuming that Article 50, having been notified, is irreversible. That is not the view of all lawyers, but it appears to be the government's position not to plead otherwise.
Agreed.
Certainly the view of one Cambridge law professor I know was that it wasn't a good decision on that basis. The Article 50 is not effectively legislation. That'll be interesting to see how that's dealt with in the House of Lords, in the Supreme Court. The question I wanted to ask is, when I was at school, we were taught that the referendums were the tools of dictators, although I think that quote was actually from Attlee in the immediately post-war period, and the period we were thinking of was the period between the wars. That view seems to have declined somewhat.
Well, I think it's what was described as the normative effect of the factual, isn't it? That the more referendums we have, the more they come to seem as a sort of mainstream occurrence. I mean, I think that I can just about remember some of the discussion around the 1975 referendum, and that was certainly a widely expressed view at the time, that these things are un-British and why are we having it? And as I think I tried to point out in the talk, a big part of the reason that governments have fastened onto this tool as being convenient is a way of resolving internal disputes, and that point, which is less often made, has something to do with the voting system, because the effect of the first past the post voting system is to force people with quite different views on certain matters into broad coalitions, and sometimes they're unable to agree, and referendums kind of give them a way out of that.
Gentleman here in the jump. Would you like to introduce yourself?
Robert Turner, individual. Do you think that might be exacerbated now we've got 5-year terms? Because the temptation for a head of steam to build up that nothing can be done about within that period.
Well, I think that sounds likely to be right. I mean, I think on the other side of it, the effect of the referendum just passed, I think, has been rather chastening, and I think it will be quite some time before a future government, unless, well, there's 2 different points. One is that we may, by events over the next 2 or 3 years, the government may be forced to hold a second EU or second Scottish independence referendum. But apart from that, I can't see any enthusiasm for any other referendums anytime soon.
I mean, the idea of going for an early general election as a way of putting a particular proposition to the public is rather risky, isn't it? Because you don't know what they're voting on, and the extent to which the salience of that particular issue influences their voting behaviour. Professor Hazel, do you have a...
Robert Hazel from the Constitution Unit at UCL. Nat, I wonder if I could pick up what you said right at the end about whether the mess that we're in possibly strengthens the case for a written constitution. And it's quite commonplace, especially I think amongst British audiences, to draw this comparison between our system and other countries with written constitutions that have the answer. And I say this very tentatively because it's based on no systematic knowledge at all, and it might be a worthwhile piece of systematic work to be done. But my impression is, simply looking around the other countries of Europe and the referendums that have been held in those countries at different times, mainly around changes to the treaties, that yes, some countries like Ireland do have a constitutional requirement, but my impression is that most of them don't, and therefore they've held the referendum essentially for what you might call British reasons, if you like, as a political expedient. I think that's the case with regard to the referendums in France, for example, and I think possibly also Denmark. So even if we had a written constitution which prescribed the circumstances in which a referendum was required, we might still have a government proposing referendums because it was deemed politically expedient for the reasons that those other European governments have done.
Well, I think in principle I'd agree with all of that, and I know the Constitution Unit is doing quite a big piece of work on.
We might call him Alex if he's done the work, who's sitting in the back row to tell us more systematically than
I would like to know the reality of that. I mean, calling a referendum not defining what the outcome of a vote for change would be and campaigning against it does seem to me to be an innately toxic combination, whether it's prescribed in a constitution or not. I agree.
I totally agree.
Yes.
Is there anything you'd like to add? Alex?
Not at this point, sorry.
Fair enough.
Still have a bit more research to do on it.
Very well. Gentleman in the third row, did you have your... No? Lady over here.
Lucy Atkinson, Constitution Society. I was just wondering, you mentioned about voter ignorance. I was just wondering what you thought about the responsibility of public knowledge and literacy, and where that responsibility should lie, and what could be done to improve that if future referendums were to be held.
Well, I think it's part of a general problem that the education system in this country doesn't seem to make any very serious effort to teach people about current affairs or constitutional or political matters anymore. That's my impression anyway. Stand to be corrected on that. And of course there is an obvious problem that if one has a written constitution, you can at least teach people at a fairly basic level what's in it. Trying to teach the British Constitution in school here, I think might be challenging. And the point about voter ignorance generally is that the principle of representative democracy, sort of going back to first principles, is that voters can't be expected to understand everything about the world in detail. There's too much of it and it's too complicated, and that's why they elect representatives to deal with these tough things for them. And then every so often we throw one of these questions directly at the electorate, and it's not a sort of do you support gay marriage question on which I'd be very happy to defer to the majority view. It's a what do you think about some immensely complicated series of international treaties which involve an understanding not only of law but of economics, which is wholly beyond most people, including most educated people. So, I'm against referendums. I don't make any bones about that, but that's not where we are. And having gone down this road, I think it's hard to stop.
Dr. Rennick.
Thank you, Alan Rennick from the UCL Constitution Unit. I think you've just answered my question in the final sentence, but I'll go with it anyway. So you said that governments should not hold referendums, should not call referendums on issues where they don't support the proposed change, which sounds very sensible to me. The question is, should anyone else be able to call a referendum? There's clearly a general argument that says that if the will of a substantial body of people is persistently frustrated, then that will create problems such as we've seen overnight. And then there's a specific argument that on certain issues, particularly constitutional issues, something like the electoral system, for example, the interests of parliamentarians, the personal interests of parliamentarians are very strongly implicated in the decision, such that we can't reasonably expect them to make a decision reflecting the interests of the public at large, and that therefore it would be appropriate to
I think there's bullshit. I'm against referendums. I think there's a kind of hierarchy of my opposition to different types of referendum. Some system where if a substantial number of people signed a petition saying that they wanted a referendum on some subject, and that would be, in my view, millions of people, and that there was legislation that caused the referendum to be held. Yeah, I can see that sort of sounds attractive, but then does the result of that trump whatever Parliament has to say about it? And if it did, the question really couldn't be a kind of one-liner. It would have to be a referendum on a piece of legislation if it was to be properly decisive, and who's written the piece of legislation. So yeah, there was some obvious, in principle it sounds all right, but in our system there were some obvious problems around it. I think the other circumstances I mentioned in the talk where a referendum is necessary and justified is when a part of the United Kingdom is actually proposing to become independent. Now, there's all sorts of questions about how that referendum should be called, how the question should be put, how often they should happen, and all the rest of it. But it's inconceivable that Scotland should become independent without a referendum, where at least a bare majority of voters in Scotland supported that.
More questions? Whilst you're thinking of your next point, can I just explore this issue about the pros and cons of thresholds a little further? Because the question that immediately presents itself is, what is it a threshold of? Is it of the total electorate, or is it as a proportion of those who actually turn out and vote? I can see why you might argue that it needs to be a certain minimum proportion of the total electorate, because otherwise you could have 5% vote sort of determining an outcome, which was then mandatory on the entire population, although very few people had actually taken part in that decision-making process. But on the other hand, if you look back to the experience of the first Callaghan-era Scottish devolution referenda, where there was a requirement for a certain proportion of the total electorate to give their assent, effectively that is loading the outcome, because those that were against didn't actually have to bother to go and vote. They merely sat at home and it had the same result.
Well, again, I await with interest the result of the Constitution Unit's research on international comparators, because my understanding is that both systems have been tried, certainly separately and possibly in combination in other countries. So a threshold, strictly, is where a percentage of the electorate have to support a proposition. That's what we had in Scotland in 1979. The alternative is a supermajority, where more than 50% of those who vote have to vote in favour for the proposition to pass.
More than some proportion higher than 50.
Indeed, yeah.
Just on that point, there is a third, which is a percentage turnout, because that applied in a recent Hungarian referendum.
Good point.
Where the opposition mainly stayed away, caused it to be incorporate rather than vote against, which might have caused it to be passed.
Yes, that very good point. I mean, I haven't really given any thought to which of these systems might be better than another, or what the numbers ought to be. But I mean, it does seem to me that if the electorate is taking a step which cannot be reversed, I mean, very interesting to speculate what sort of debate we'd be. Immediately after the EU referendum, some people tried to argue that this was not a legitimate result because it wasn't a big enough majority, people had been lied to and so on. Now, some people privately probably still think that, but you don't hear politicians saying it anymore. So everyone has accepted that 51.9% is if not a decisive result, at least a proper result. What people would be saying if the result had been 50.1 to 49.9 is interesting to speculate. What they'd be saying if it had been won by 10 votes is interesting to speculate. So the principle, given the asymmetric consequences, the principle of some threshold or supermajority does seem right to me.
Just on that same point, isn't it? Don't you actually need two considerations. One, a clear margin, but two, a minimum participation.
Yes.
But that has to be set by reference to the percentage in supporting the change. So otherwise you introduce the incentive not to vote.
I haven't thought about this enough, but that sounds likely to be right. Yeah.
We discussed this at great length 40 years ago.
Right.
Anybody else? Alan?
What do you think the situation would have been today had there been a 60% threshold? What would be the discussion going on today? Would it have been seen as legitimate?
Well, assuming that the result was the same. I mean, not by the Brexiters, no.
But I mean, there's a real concern about if you impose a threshold such as that, do you delegitimise the process in a way that could be quite damaging?
Well, I think we come back to the normative effects of the factual, that people have got used in this country, but not necessarily in other countries, to some proposition, even if it's irreversible in nature, passing on a majority of one vote. And if we were going to have more referendums in the future, and we're going to look at these ideas of threshold and supermajority seriously, I mean, clearly there's some process of public education that needs to go on there.
There are a number of people present who are hugely knowledgeable about political and constitutional issues generally. I wonder if there's anybody present that's looked at the use of referenda at local government level rather than national or devolved government level, and would like to contribute any views drawn from those experiences. There's this asymmetric requirement for local authorities to hold referenda if they want to put council tax up by more than a certain percentage, but no corresponding obligation on them to consult their electors if they wish to put it down by the same proportion, which always seems to me to be rather prejudging the outcome, or a rather value-laden requirement. My professional background was in transport planning, and there's a general consensus among transport planners that the era of predict and provide is over. You've got to manage demand for finite volume of infrastructure capacity. But the city fathers of both Edinburgh and Greater Manchester didn't have the courage of their convictions to introduce road pricing without putting that to the test of a local referendum. In both cases it failed because the consequences for those people who saw themselves as being adversely affected were direct and immediate and hit them in the pocket, whereas the benefits would accrue to a much wider cross-section of the population, but much more widely diffused. It would only have been delivered in the much longer term if the money that was derived from income that was derived from road pricing had then been recycled into investment in environmentally friendly transport modes. So it was a very unequal debate. A lot of people who feel strongly about something, they may be few in number, but they have a powerful incentive to turn out. The much larger proportion of people for whom there might have been benefits, but individually the degree of benefit would have been relatively modest, didn't feel the same incentive. And certainly I felt it was I'm making a value judgment here, but I thought it was a very poor way of resolving that issue. But that's my view. But it may be that...
Are you bringing us on to one of the great dilemmas in democracy, which is the balance between majority rule and respecting the rights of minorities? In your example, the minorities are the people for whom the charging would bear particularly unfairly, which was a major part of the Manchester problem. I don't clearly remember the end. But in fact, it applies all across the board now, the extent to which a majority can impose its will regardless of the views of the minority. It's a major part of the debate now following the Brexit referendum because the minority is so large. And it is a fundamental problem for liberal democracy down the ages, which has never been entirely... Well, the Americans resolved it by their balance of powers and checks and balances, which will be interesting to see be exercised or not again with Mr. Trump.
Indeed. Nigel.
I'm Nigel Cedar, I'm a trustee of the McDougall Trust. Just on the point that you made, John, you don't hold me to the exact figures, but the area in which I live, the London Borough of Lewisham, had a vote on should there be an elected mayor, and roughly speaking, 85% of the local population did not bother to vote, and the proposition was passed by 8% to 7%. And we've got an elected mayor, for better or for worse. Now, that seemed to me to be, an example of not good democracy in practice, where a majority of the people voting were able to impose a system about which the majority didn't give a stuff.
Indeed, and the electorate was given a direct say into, as it were, the internal structures of the council, what the relative powers of the mayor and the councillors should be. But the government feels free to create and abolish whole counties, a stroke of legislative pen, without any kind of similar recourse to a test of public will at all. Any other issues, questions?
Can I jump
Please,
back with
please
it? Something we haven't really talked about yet are regional differences in the result of the referendum and why those might matter. And the argument which the government advances is because the people have spoken, MPs are really morally obliged to vote to invoke Article 50 and not make too much fuss about it. It sounds sort of superficially right, but then you think about it, is it really? I mean, who are MPs representing? They're not representing the country as a whole, they're representing their constituents. So if I'm an MP representing a London constituency and 75% of my constituents voted to remain, am I really under some kind of moral obligation to vote for Brexit? I mean, you could equally well argue that I was under a moral obligation to vote to remain. And this point applies particularly strongly in Scotland, where we have a unified bloc of SNP MPs who definitely are not going to be voting to invoke Article 50, advancing the, at least to their minds, perfectly reasonable argument is that we don't represent the people of Britain, we represent the people of Scotland, either in individual constituencies or possibly collectively, and they voted the other way. And this is why I think if we are going to have a proper constitutional crisis, it is going to be over Scotland rather than anything else. So if you look at how that might play, and of course the future's unknowable, but let us say that the Supreme Court upholds the decision, and that is interpreted prudentially by the government as being a requirement to actually have an Act of Parliament to invoke Article 50, and they invoke such a bill. Well, some MPs on the Remain side will try and amend it unsuccessfully, but it will pass the Commons and it will go to the Lords, and the Lords will make a more concerted attempt to amend it, and it will go on and on. If the Lords push it too far, there may be a general election. This is all speculative, but the point I want to make is that in any confrontation between the Commons and the Lords on this issue, in the end, the Lords are going to back down one way or another. It's a delaying power. It's not a power of fundamental obstruction. That may not be true of Scotland. There's an interesting and little-known change that occurred in the Scotland Act 2016, which is that the Sewell Convention, which has previously just been that, a convention that legislative matters, legislation passed in Westminster which affected Scotland, had to be approved by the Scottish Parliament using a mechanism called a legislative consent motion. That was simply a convention. So if in this case, under the old rules, the UK government had succeeded in getting their bill through the Westminster Parliament, and there was an act which said Article 50 will be invoked on such and such a date, and the Scottish government had put up a legislative consent motion in the Scottish Parliament and voted it down with their majority, nothing would have happened except people would have got quite angry, and it might have wound up a few more Scots to demand a second independence. referendum. But since this convention is now in statute, it is potentially justiciable, and there are different views about that. But let's say, at the very least, you can see all of this going back into another round of hearings by our friends the judges, the enemies of the people, on the question of whether this piece of legislation can be implemented either in respect of Scotland or at all without the consent of the Scottish Parliament.
Is that not one of the cases that we when they intervene in the Supreme Court?
They've sought to join the action, haven't
When they join the action?
Yes, but I'm not quite clear how that can be decided at this stage, because that's not what the appeal is about, but I'd defer to experts on that.
Professor Hazel, do you...
I was going to make just that point, but widening it and coming back to, again, the idea of the possibility of a written constitution and thresholds. If we were to have a written constitution, and if it were to have a federal or something approaching a federal structure, then, as happens certainly in federations like Australia and Canada, there could be a requirement of a supermajority of the states or the provinces, in our case the 4 nations of the UK, to vote for a change, for it to be carried. Then that broadens into another point about thresholds, because the purpose of thresholds, as I've heard the argument, and I agree with it, is to make change more difficult, essentially, because, as you've said, the change is, in most cases, irreversible. And there's a whole range of other ways in which that might be achieved, and this is a menu from which one can pluck, one or more items. I've mentioned one, which is a more federal kind of structure with essentially veto rights of the kind that Isabel reminded us the SNP argued for during the passage of the bill but didn't succeed. But another might be to have a requirement for a second referendum, and as you know, this is also occasionally mooted. It was in the context of the Scottish independence debate because the terms of independence were not at all clear, and the terms of Brexit are even less clear. But a second referendum, again, makes it slightly harder to achieve the change, or generally you can't achieve the change finally until you know exactly what the change amounts to. Then you may be able to think of other ways to, in effect, raise the threshold higher.
I think where you've only got 4 participating states or nations, by definition a majority and a supermajority would be one and the same, because you'd have to have 3 out of 4, otherwise you'd have a dead heat.
You could require 4 out of 4.
You could require unanimity. Yeah, that would be true. This question about whether individual MPs could justify opposing an application for Article 50 by reference to the result of the referendum ballot in their own constituencies only arises because the results were published and made known on that basis. Well, forgive me whether they were published on a constituency basis or local authority basis, which in some cases enables you to infer what the constituency result would have been. But why are they published on that basis if it's a national referendum? Discuss. I mean, what relevance does it?
That precedent was established in 1975. The original idea in 1975 was to hire Olympia for a fortnight and bring all the ballot papers to London and count them until the bureaucrats were talked out of this idea about local authority administrators and persuaded to do the counts locally.
But we don't publish parliamentary results on the basis of polling stations.
Well, no, we have those figures for Cambridge because that's the way they count. The reason we don't know the precise constituency figures is because of the way postal votes were handled. So we have the on-the-day vote for the one ward not in the Cambridge constituency figures, but we don't know where its postal votes were counted. And so they are on top of the Cambridge figures, but the numbers are relatively small in terms of giving an MP an indication of the result in his constituency.
Further contribution?
Understood that to say that didn't think that Parliament would go for referendum quite so much in the future, that people are more restricted. I thought that's what I heard. If I did hear that, then I would challenge that, because I think parliamentarians sort of work on what's the best for them this week, as opposed to learning lessons from the past.
Well, maybe that's right, but you do meet quite a lot of people now, and they're not all disappointed Remainers who think that this has really not been handled very well, and that we have opened a Pandora's box.
Any final points? Well, thank you all very much indeed for coming. It's been a very stimulating presentation and a very thoughtful array of contributions from the floor. I'm very grateful to you. I hope you all, I don't know that we've resolved any questions this afternoon, but we've certainly explored some. And it's a debate that I sense is going to run and run. So thank you very much indeed, Nat, for kicking off the discussion and helping us to crystallise our thoughts about all this. Hope to see all or most of you next month when we explore the pros and cons of digital democracy. But have a safe journey home. Thank you very much indeed for coming. Thank you.